Welcome to the Supreme Court of the United Kingdom, where we are today continuing the hearing in the case of Lloyd and Google. We're currently hearing submissions on behalf of Mr. Lloyd, presented by Hugh Tomlinson, Queen's Counsel. So I'll turn now to Mr. Tomlinson and invite him to continue his submission.
Thank you, my lord, and good morning. Yesterday afternoon, I was making submissions on the first issue before the court, and under the subheading of damages for loss of control in data protection. I told the court I was going to deal with 7 points, and I dealt with the first 4 of those. So I'll move immediately on to my 5th point, which concerns the concept of the de minimis threshold, below which damages we say will not be awarded under Section 13. It's common ground, I think, that there is indeed such a threshold, because not every infringement of data protection rights necessarily involves a loss of control. We don't apprehend that there's any objection in principle to the court's ability to apply a triviality or de minimis threshold. It's a well-known test in approach in many areas of the law. As we understand Google's objection to the way we put our case on this under this head, is that the only matter that can be had to which regard can be had in relation to a de minimis threshold is the damage caused and not the characteristics of the breach. We say that when considering whether the breach is de minimis or not, the court can have regard to both factors, because factors which relate to the seriousness of the wrongdoing, for example, whether the wrongdoing is done deliberately for profit, are relevant to the seriousness of the infringement of the rights of the data subject. I addressed yesterday briefly, and I said I'd come back to it, the contention that under Article 8, the court only has regard to the level of damage and not to the and the impact on the individual, and not to the seriousness of the breach. True it is, and the court's been referred to a number of discussions. In general, Strasbourg focuses, insofar as it takes a principled approach to just satisfaction, which is perhaps sometimes difficult to discern, focuses on the seriousness of the breach, but it also makes focuses on the consequences to the individual, but it also makes awards which reflect the seriousness of the breach. And I made reference yesterday to the case of Holford and the United Kingdom, which is to be found at electronic 1338. In that case, the court can see the nature of the claim. It's helpfully summarised in the first holding, 1365. I'm so sorry, 1338. It involved the monitoring of telephone calls of a police officer, and the applicant having been the former, I'm reading now from the head note at 1338, the former Assistant Chief Constable of Merseyside, and her calls had been intercepted, and she alleged the violation of various convention rights. And the first holding unanimously that Article 8 of the Convention was applicable to the complaints. And then the court went on to hold that there had been violations of Article 8 the second holding in relation to the calls made on her office telephone. And just satisfaction, non-pecuniary loss, is dealt with at paragraph 76, was it 1365 of the electronic bundle. And there the court notes that she claims that damages were claimed for distress and indeed for what we would describe as psychological injury. The government, 75, the government commented that there was no causal link between the stress and the interception of telephone calls, because Ms. Holford had been engaged in tribunal proceedings in any event. And at 76, the court noted that the interception of calls appeared to be carried out by the police for the primary purpose of gathering material to be used against her in sex discrimination proceedings. It considered what occurred to have amounted a serious infringement to the rights of those concerned. On the other hand, no evidence suggests the stress suffered was directly attributable to the interception of her calls, rather than to the other conflicts of the Merseyside police. Having taken those matters into account, the court then made an award of £10,000 for non-pecuniary loss. That's a case which the court will perhaps recollect that was considered and taken into account in the Gulati case when looking at the question as to whether damages could be awarded for loss of control. And we say that this kind of analysis is particularly apt when we're dealing with data, which really is we say important to understand that in the world of data, it's very easy to gather and then it's processed at very great speed by multiple companies, multiple platforms, and the person whose data it is has really no control over what's happening to their personal data, the way in which it's bundled, used, and exploited. The phrase is often used that this is a wild west, and we say that in those situations, the control is of crucial importance, and that why and how the intentions and the nature of the breach are matters which can properly be taken into account to decide how serious the breach is. We note, just in passing, that references made by the Court of Appeal to Article 85 of the GDPR, which refers to control. We draw attention to its bundle is long enough as it is, and this bit of the GDPR hasn't made it into the bundle, but recital 7, which is cited by the second intervener at supplemental bundle 135, recital 7 says in terms, natural persons should have control of their own personal data. We say that that's obvious, but the extent to which that control is interfered with, the seriousness of the breach, is a matter that can properly be taken into account in looking at de minimis. My sixth point.
I may I just ask you something, Mr. Tomlinson, before you move on to that?
I'm so sorry.
Am I right to understand that by loss of control, you don't confine that to loss of control by the data subject? I mean, in this particular case, the claimants had control of their data in the first place, and or should have done, and it was used without their consent. But in many cases, the data controller is different from the data subject. The person who keeps records for any purpose is a data controller. And if their system is hacked, let's say, and they lose control of the data, that counts as loss of control as far as you're concerned, as I understand it, even though it was that even though the claimant didn't have control of that data, the data controller was someone else.
Well, my lord, no. The data controller obviously controls the purposes for which data is processed, and that's the absolute essence of the scheme for data protection, is that those who determine the purposes for which personal data is processed are data controllers, and they are subject to certain obligations. We don't complain if a data controller loses control in that sense. That's not by means of a hack. We don't complain. We don't say that that's a loss of control which is actionable by the data subject in itself, because of course it may well be that, and very often hacks are not the fault of the data controller at all.
But let's suppose that the data controller failed to take adequate measures.
Well, if
and in that sense was perhaps negligent. You say that's actionable without proof of harm, do you?
Yes, because the position is that the data controller, negligence is a good way of putting it, although it's not the way it's put in the GDPR or the Data Protection Act. In effect, the data controller is under an obligation to take reasonable care of the safety of the data. If the data controller fails to take such care, then the data, as a result, the data falls into the hands of possibly malign actors. Then absolutely the data subject has lost control. I mean, a paradigm example.
That seems to be quite an extreme position, because most negligence is not actionable without proof of harm. If I cause you personal injury through negligence, that's only actionable because of the injury, not if I don't cause you any injury, but I've been negligent in my behaviour towards you.
Well, my lord, that of course that's absolutely right. But the complaint is not the negligence. The complaint is the failure to obey the rules that apply to data controllers. And data controllers are subject to a series of complex, I accept, series of rules which are set out nowadays in the UK GDPR and in the old days in the Data Protection Act 1998. If they fail to obey those rules, some of which involve failure to take reasonable care, then the data subject, their data is potentially exposed to misuse by malign third parties. That's what the data.
And being exposed to the risk of that, even if they suffer no actual harm, that's enough to get them damages on your analysis.
Well, and it is that's right. And the being exposed to the risk of it is one of the things about data is once it's out there, it can be copied endlessly, it can be transferred to all kinds of third parties, and no one knows what's happened to it. And the classic data breach problem involves situations where thousands, perhaps millions of pieces of personal data have got into the hands of malign actors who then may or may not use it for nefarious purposes. And we say that is an actionable, absolutely an actionable loss of control of that data, because that data it should be being protected in accordance with the statutory rules by the data controller.
And so somebody who's negligent there is, and perhaps controls a lot of data for good purposes, but it gets broken into. No actual harm is caused, but a class action can be brought on your basis, and everybody can get, a million people can get £500.
Well,
is that right?
Well, it is right, but the other way of putting it is that if the data controller fails to take proper care of my data, it gets out there into the hands of criminals. I have no idea what's happened to it. And in practice, I have no remedy in relation to that, because if we're wrong about this, if the Court of Appeal is wrong and the judge is right, nothing can be done. There's no civil remedy of any kind, because in practice, it's just not possible to bring individual data protection actions. So if my data or your lordship's data are bank details or other matters go out there onto the dark web, we have no civil remedy against the data controller. Now, my lord, that may be a consequence which your lordship thinks as a matter of policy is perfectly reasonable and proper. But what we say is from the point of view of the data subjects, the consumers, the law should provide them with a remedy in that kind of situation. My Lord Burrows, I had a question.
Thank you. No problem. Can I just take you back to the Holford case before we leave it? So, as I understand your submission, the lossing question being talked about under the heading here of non-pecuniary loss is a loss of control.
That's how we would describe it in
Now,
terms of recent English authority.
The question I then have is, how can that be affected by whether the breach is deliberate or more or less culpable or aimed at profiteering? Surely, if you're focusing on the loss of control, it doesn't make any difference what the culpability of the actual breach is, does it?
Well, we would say yes, because the person is entitled to have their private information or their personal data protected against disclosure, if I can put it that way. And the effect of removing that protection deliberately, we would say is more serious than the removal of that protection accidentally.
Well, it's more serious as a breach, but we're looking here at non-pecuniary loss. We're looking at the effect on the claimant. Now, if the loss is conceptualized as a loss of control, I'm finding it difficult to see why the culpability of the breach is relevant.
Well, my lord, we say that from the point of view of claimants, losing control of your data or your private information, where someone has deliberately given it away or removed control, is a different, a more serious and different wrong from one where it's been done accidentally.
No, well, I'm accepting that, but you are saying that there is a greater quantum applicable to the loss of control if the breach is more culpable rather than less culpable. That's what I'm struggling to follow.
Lord, I am saying that, yes.
Well, it sounds to me, I mean, I'm putting it to you now, that what you're focusing on is not the loss of control. You're focusing on the nature of the breach, and that is what you're seeking the award for, that this isn't compensation at all, that you are, in effect, talking about something like vindicatory damages, because you're not concerned with the effect on the claimant. You are rather concerned with the manner of the breach.
Well, my lord, I'm certainly, and as your lordship knows, for reasons which concern the constitution of a representative action, I can't focus on the individualized circumstances of the claimants, because that would make it impossible to have a collective action. So I am focusing on the nature of the breach. I can see that that may be described, and it's difficult quite to. We get into semantic arguments here, but that might be described as a form of vindication or a form of conventional award. I'm going to deal with that a bit later on.
But might it also be said, I'm sorry to interrupt, might it not also be said that this conduct is relevant to the valuation of damages and thus to a constituent element of the tort? Because you might have to make assumptions as to what damage was caused. I very much take your point that once you lose control of a piece of data, it can be very, very difficult, if not impossible, to track it.
Well, my lady, that's certainly the case.
So you might have to make assumptions about damage.
Yes. My lord, I'm so sorry. Lord Sales has been seeking to.
Sorry,
Not at all, Mr. Tomlinson.
I feel responsible for not allowing your lordship to speak. I apologise.
No, you were. Don't worry. You were answering other questions. But I did have a question myself about Halford. I mean, I do wonder whether your interpretation of it is correct, because Miss Halford wasn't claiming damages for loss of control. She was claiming two things: distress and a sort of acute form of distress, namely stress in terms of psychological harm. And it looks as though, to me, as though the court in paragraph 76 upholds the claim to distress while rejecting the claim to stress in the form of psychological harm. And I rather think myself that the focus on the seriousness of the breach is because that feeds into the distress. Going back to the Oliver Wendell Holmes quip that a dog knows when it's been kicked and when it's been stumbled over, that it's more distressing in the circumstances in which Miss Halford found herself that the police had targeted her in this way to try to deal with her sex discrimination claim that she had brought against them. Isn't that a better interpretation of paragraph 76?
Well, my lord, it's certainly right to say she wasn't claiming damages for loss of control, in the sense that's not a concept which makes any appearance in the case, and perhaps it appeared in the jurisprudence at all at that time. And her claim, of course, is, as your lordship knows much better than I do, in relation to in Strasbourg, the claim is for just satisfaction, and it's not conceptualized in the same way as an English damages claim would be conceptualized. So Ms. Halford says, I need just satisfaction, and I need just satisfaction for the following reasons. My telephones were unlawfully intercepted because I was bringing a sex discrimination claim. This has caused me distress, and this has caused me stress. My lord, as I read that paragraph, and
well, and just to pursue that, and isn't she saying, and the distress is all the greater because I was targeted in this completely unlawful way by a police force?
My lord, I'm sure she's saying that, but it doesn't seem to be that on the face of it doesn't seem to be what the court accepted. What the court seems to be saying, and this is a very familiar situation in these kind of cases. You say, well, look, you were distressed generally by all these other things, and so what actually happened to you in your relation to your telephones really added nothing at all to your distress. You were subject to these stressful industrial tribunal proceedings, and so the breaches you complain about didn't make anything any worse. However, we're still going to give you an award of just satisfaction because of the outrageous way that your telephone was intercepted. That's the way I read the judgment. But Lord, I accept, as I hope fairly, that it's difficult to subject to this kind of Strasbourg analysis to find textual inquisition, because it really isn't very clear. But it's certainly
very much.
As authority
you.
for that proposition in previous English cases.
Thank you.
You are getting rather a barrage of questions, but can I just put one more to you?
Well, that's what I'm here for, to answer the court's question.
Well, what's going through my mind is this: that you're telling us really that either we allow this form of action to proceed, or entities like Google can behave as they please with impunity unless a regulator chooses to take regulatory action. And I'm thinking about the the group litigation that there is at the moment against British Airways, arising out of the hacking of its, well, a cyber attack on its system, which led to customers' details ending up, as you put it, goodness knows where, possibly on the dark web. Now, there's a GLO there with currently 23,000 claims, according to a judgment issued recently. And the deadline's been extended because they think they can get another 20 odd, but about the same number again of claims if they advertise it. Now, it sounds a rather similar case to this one, but there it's being done by way of a GLO.
Well, my lord, it was accepted by the judge, and I don't think it's ever been in contest that a GLO wouldn't have been practical in this case. My lord, again, I'm entirely upfront about this. I mean, the position is that in order for such actions to be viable, it's necessary to obtain commercial funding. The costs of putting together a group are very considerable because each member of the group requires separate legal representation. They've got to be advised as to their liabilities and so on. And if the damages are of the order of a few £100s, the cost of putting together the group, which are not recoverable as costs from the other side, that's one of the decisions that Your Lordship may be referring to. That point was made a few weeks ago in a decision in the Weaver litigation Your Lordship is referring to. It's simply not commercially viable. It simply does not work as a commercial proposition for someone to fund that kind of litigation. Lord, I think this has been common ground in this case throughout. If it hasn't been common ground, it was certainly what something that the judge said at first instance. And the other point is that although a certain amount was made of the money going to lawyers and commercial funders in this kind of litigation, and of course, as my lords know, this point has been made repeatedly in respect of other jurisdictions. But GLOs are much more expensive from that point of view because there are every member of the group has a solicitor, and there are usually groups of lead solicitors. There's often disputes about the disputes between the solicitors as to who should be leading the group. There's a group register which has to be maintained and kept up to date, and so on. And so the experience of my lord, as I understand it, I'll be corrected if I'm wrong, but there's reference in one of the articles to the difference between the opt-out and the opt-in procedure under the Competition Act. And the opt-in procedure is effectively the Competition Act version of GLOs, and the opt-out procedure is the version of the procedure that we're seeking to advance in this case. And I think to date there's been no, or perhaps just one opt-in action in the competition tribunal, just because of the financial and practical difficulties of putting such an action together.
I see. Well, that's very helpful. Thank you, Mr. Thomas.
My lords and my lady, I think I'm now on to my sixth point, you'd be pleased to know, and that concerns lowest common denominator, and a number of, I know the court was concerned about this, and a number of questions were asked yesterday. And the first point I want to make about this is that, and I'm sure the court has this in mind, but it's important, that we are absolutely the very earliest stages of the proceedings. The proceedings haven't yet been served. Our present state of knowledge as to what actually goes on is very limited indeed. Obviously, we've had no disclosure. We simply don't know what's happened to the data. If we look at if the court looks at our pleaded case, that's at paragraph 22 of the draft particulars of claim, which is at page 287 of the bundle. at paragraph 22, we set out the information that we understand is obtained on a single visit. So this is the once a double click ID cookie has been sent to the browser, the browser generated information, the following information is obtained. And your lordships, your ladyship, see the list of information that's there obtained, and that includes not just the time spent on the websites and so on, but the IP address of the browser, which often enables geographical location to be ascertained. The only evidence we have from Google about this is, at the moment, is in Mr. Barker's witness statement, which is at 432. And he simply says that the browser-generated information contains various pieces of information, including the type of browser, the operating system, screen resolution, IP address. He doesn't give us a full rundown on what there is, but it certainly contains that on Google's case. If we then look at paragraph 25 of the particulars of claim, the draft particulars of claim at page 288, what we say is that the defendant then aggregates information from users displaying sufficiently similar patterns into groups with labels, and we give examples as we understand it, which group labels its double-click services then offer to advertisers subscribing to the AdSense service to choose from when selecting the type of people from whom they want to direct their adverts. This is what we understand happens, and I say it's our understanding is very limited at the moment. Now, I want to clarify a point raised by my Lord Reid yesterday. It's not a question of someone maybe looking up the meaning of a word on an etymology website, a very useful websites you find to look at etymology, or a dictionary website, in contrast to someone who's looking at some pornographic website or something that may be thought to be socially reprehensible. Google's not making a list of the websites you visit, but for the purposes of knowing how morally questionable you are. What Google is doing is trying to obtain a profile for the purposes of selling that profile to its advertisers. So it's as interesting to Google that you're looking up words as it is that you're looking up pornography, because put crudely, if you're looking up words, you might be a suitable target for the selling of dictionaries, if you see what I mean. But it's much more sophisticated than that. I mean, this is a $1 billion industry which Google is a large cog in the machine, but certainly not the only cog. This data is being packaged, transferred, sent around the world, and then used for commercial purposes. We don't know how that's happened in any case at the moment. We don't know any, apart from those very wide generalities that we put in our pleading. That's all we know. We're suing for loss of control suffered by every data subject whose BGI, browser-generated information, is taken and then stripped down into component categories. At the moment, we don't know what the lowest common denominator of that is. And for Mr. White to say, well, someone might have switched it on for 10 seconds and just received one cookie. Well, possibly. And possibly, what uses does Google make of that kind of information? We don't know. So what we say in terms of the criticism of the Court of Appeal for not addressing this issue, it's perfectly correct not to address this issue at the stage of service out of the permission to serve proceedings out of the jurisdiction. We're just too early. Under this head, Google makes the point which Mr. Justice, taken from Mr. Justice Warby, if you like, the surprise party point, that you know, some people don't mind. Some people think it's a jolly good idea for my data to be sent around the world because it will help people to send useful adverts to me. Well, the position, our answer to that is, first of all, we don't accept that if you say to people, is it all right for me to unlawfully take your data? They say, oh, that's fine, you know, do what you like. We don't care about your legal obligations. Take whatever data you want. We say that that's a hypothesis that can't be certainly made at this stage. And in any event, you can't contract out of GDPR data protection obligations. You can't say, actually, I agree that you can't say to a data controller, I agree that you're not going to be subject to the law. You can certainly consent to your data being used. Consent is a as the court may be aware, is a very strict concept under the terms of, it's got to be explicit, and now under the GDPR it's got to be confirmed. So we say that the court shouldn't say, well, we can operate on the hypothesis that people would have agreed to this, so the lowest common denominator suffers no damage. We say that's a bad point. So that was my sixth point. My seventh point is a more mainstream legal one. Mr. White began his submissions by referring to the case of Cullen and the Chief Constable of the RUC, which is at 1814. I don't think it's necessary to turn it up. And he referred to that case because obviously this case is also an action for breach of statutory duty, and that case was an unsuccessful action for breach of statutory duty. Of course, the court will have seen the important point of distinction. It is in the RUC, the Cullen case, what the claimants, with the plaintiffs in those days, were trying to establish was that the particular statute in question, providing right to access to legal advice, created a private law right to damages. And there's a very long history of this question going back to the 19th century as to whether in a given situation a statute can be construed as giving rise to a private law right to damages. And for that reason, much of the judgment of Lord Hutton for the majority is tied up with, it's concerned with looking at the question of whether there are alternative remedies, because that's a crucial question deriving from the well-known case of Cutler and Wandsworth Corporation. But none of that's relevant here, because of course this is a statute which does give rise to an action for breach of statutory duty. It says so in terms. So that issue which concerned the court in Cullen is simply not relevant. We have a statute that gives rise to an action for breach of statutory duty. The question is, what kind of action is that? And Mr. White says, and of course I accept, that in general, actions for breach of statutory duty are actions on the case. In other words, they're not actionable without proof of special damage. However, that's not the case in relation to the Data Protection Act. We know that because under the Data Protection Act, you can recover damages for distress without proof of special damage. And that's it's forgive me for making an obvious point, but the reason why negligence is an action on the case is you can't recover damages for pure distress in negligence. You've got to prove material damage. If you can recover, we say that this, under this statute, this is akin, at least, to, it would be in traditional terms referred to as categorized as a tort actionable per se for that reason. My lords, my lady, these are very deep waters in terms of the precise analysis of the way that the English law of tort deals with questions of damage. We cited, I hope not wrongly, the famous dictum of Lord Holt in the well-known constitutional case of Ashby and White. Mr. White, no relation, said in relation to that case, well, it's all being dealt with in Watkin and the Home Secretary. In fact, in that case, where my Lord Sales successfully argued that misfeasance in public office is an action on the case, what Lord Bingham said probably not necessary to turn it up, but it's at paragraph 14 at 259. What he said about Ashby and White was, well, really it was perhaps a case of quasi-trespass, because Lord Holt had said it was actionable without special damage. But if it was misfeasance in a public office, then all the authorities showed that misfeasance in a public office required proof of special damage. And Lord Sales successfly argued that line of authority was one that Court of Appeal had misunderstood in that case, and that in the absence of proof of special damage, the claim must fail. The details of the analysis of this are a very hotly contested academic subject, and one member of the court is, of course, a distinguished contributor to those debates. I apprehend it's not controversial to say that the academic commentators don't speak with one voice, and I'm not, unfortunately, I don't have the time. Perhaps the court would be wearied if I did, to go into some of the details of those debates, but associated with the names of my Lord Burrows, Professor Stevens, Professor Varus, and others, who have taken slightly different views as to the way that the tort treats damage and damages. But perhaps I can refer to just one academic article which is in the bundle, which is at page 3670. It's an article by Professor Eric Deschimak, I hope I pronounce his name correctly. He sets out two different analytical frameworks. One which he refers to as the bipolar model, where the wrong is transparent, the law is simply seeking to compensate detriments, which are the pecuniary losses or mental distress. And the other model conflates the wrong and it's a diminution of the right itself which is compensated. And he says this on that page, that the English law has been meandering between two incompatible analytic frameworks some time. And my lords, my lady, well, it's perhaps not the first time the common law has been accused of meandering, and that may be a strength rather than a weakness. But what we say is really the simple point that, and we say not really sensibly contestable, that there are numerous examples in the law reports of cases where substantial damages have been awarded for infringement of the right itself. So there's no unorthodoxy in the Court of Appeal's conclusion that this kind of damages are recoverable where someone is, to use Lord Holt's phrase, hindered in their right in a case of this kind. True it is, as Lord Leggett pointed out yesterday, that mere trespasses, mere interferences that don't cause consequential damage are not likely to attract large awards of damages. I think my recollection is he gave the example of a mere touching. And if anybody's sued over a mere touching, they're not going to recover very much, perfectly obviously, in Lord Camden's famous phrase, if I put my foot on another man's land, then Entick and Carrington, he's entitled to compensation. It's not going to be very much, of course not. But we say that this applies in this case. Yes, the damages are small, the interferences are small. Particularly on the lowest common denominator basis, but speaking more generally, it's unlikely that anybody will have suffered substantial material or non-material damage from Google's, what we say is Google's wrongdoing in this case. Some people may have suffered significant distress. It's very unlikely that material damage could. But that, we say, is a reason in our favour, because it follows that the only way that any recovery can be made in respect of such interferences is through the mechanism of a representative action as we've sought to set it up. Of course, one response that's made to us is and indeed the judge made it, was, well, nobody really minds about this. Nobody really cares, and the law shouldn't be concerning itself with trifles and worrying about small interferences with data rights. The data companies should just be able to get on with it. Well, my lords, my lady, that's not right, certainly in respect of one person. Mr. Lloyd, who is the representative claimant, and also someone whose data has been wrongly processed. His credentials as a consumer advocate are not challenged in this case. He's a long-standing and very distinguished consumer advocate, and he brings these proceedings in that capacity, partly for that reason. He's concerned about it. He's concerned on behalf of consumers, and he seeks to do something about it. And the issue in the case is obviously whether the Court of Appeal's innovative approach is one which is good in law. This court will uphold. So, my lord, my lady, those were my points under loss of control. I now want to deal with...
Tomlinson, just before you move on, if I may.
Of course.
Yeah. Your approach to the lowest common denominator, and in the light of what you've just said, are you accepting that the lowest common denominator may very well be a trivial loss of control, and that therefore one would end up, if one went down this route, with a very small sum of compensation for loss of control?
It may be very small. I certainly accept that, and Lord, I think I have to say I accept that I have to go with the logic of my position. If it's trivial, then it wouldn't be compensatable in damages at all. I think I have to accept that. I now want to say something about conventional sums and vindicatory damages. Mr. White said in his submissions, well, let's look at the substance of this, and the substance is that this is a, let's not look at the label. This is a conventional award, a vindicatory award of the kind rejected in Lumber and disapproved by the Court of Appeal in Shaw and Kovacs. We say that argument was rightly rejected by the Court of Appeal. That's at paragraph 63, 224 electronic. But if a conventional award means an award made on a non-individualized basis to compensate someone for something other than consequential loss, and instead to compensate it for, I think Mr. White used these words, a detrimental impact on rights and freedoms, then yes, that is what we're seeking. It's another way of putting the claim. It's interesting that Lord Justice Davis, who was of course party to the Court of Appeal decision in this case, and gave the judgment in Shaw and Kovac, noted at paragraph 53, that's 2968, that the privacy cases might have a special status in relation to conventional sums. And I hesitate slightly because we would say in a way this is simply a matter of labelling. But if we're labelling the award as a conventional sum, then privacy cases do have a special status. Privacy and data protection cases, I've already indicated why in privacy cases there's loss of control damages and why we say that should apply in these cases. And then for the reasons which I've made more than once, and I apologise for repeating it, but it's the heart of my case, that where large numbers of consumers have relatively modest claims, a claimant by claimant assessment is not realistically possible. So without a conventional award in this sense, there is no, there's no effective remedy. We note in passing in our case that the law has long recognised conventional sums in a number of situations. There were, prior to the enactment of the Administration of Justice Act 1982, conventional sums were awarded for loss of expectation of life. We refer, that's referred to in Shaw at paragraph 78 to 973, and of course there's the decision of the majority of the House of Lords in Rees and Darlington Memorial Hospital, where a Lords Bingham, Nichols, Millett and Scott made a conventional award to a lady who had a child as a result of medical negligence. The costs of bringing up a healthy child were not recoverable as a matter of policy, but it was unjust. It was said it was unjust that she should be denied any recompense, and a measure of recognition for the wrong would be a conventional award. Lord Hope in the minority, for example, paragraph 74, said that this was wholly contrary to principle, but he was in the minority, and we say that the case shows that in an appropriate case, if the label conventional sum is right, if what we're talking about is a conventional uniform sum, there is no objection in principle to such a sum being awarded. It doesn't. If I can put it this way, as I said at the outset, a representative action for damages requires an aggregate amount without individualized assessment. That can be top down or bottom up. We're not in a top down situation here, but a uniform sum of a conventional nature would enable a bottom up assessment to be conducted. And that's not a radical departure that we would say, not a radical departure that requires legislation, as perhaps the constitution of a top-down sum would require. My Lord Legate.
The two examples you gave, examples of situations where it would be invidious for the law to try to make a personalised assessment of harm, or perhaps of harm at all. And so the appropriate thing to do is just to make a conventional award which just marks the wrong. That's miles away, isn't it, from this sort of case where the law is perfectly able to assess harm on an individual basis, or indeed the seriousness of the breach on an individual basis. And it would be wholly inappropriate to have a standard award that you hand out for every breach above the trivial, regardless of all the factors that make it more or less serious. It's exactly the sort of case where you have to tailor the award to the wrong, don't you? And to the harm that it caused, if it did.
Well, your Lordship uses the term invidious. It would be perfectly possible in line with established principles for the court to assess how much distress that the mother had suffered as a result of the birth of the healthy child. I mean, those are conventional sums, of course, in one sense. They're money sums to substitute for distress.
But there's a policy in those cases that it's not appropriate to regard, whatever you think of the policy. You said it yourself, didn't you, that it's not appropriate to start regarding the birth of a healthy child as some form of harm.
Yes, well,
take sense of, and then give an award based on that.
Yes, but again, loss of expectation of life. I mean, in principle, you could devise a system analogous to personal injury damages to compensate for that. It's a tool used by the common law in circumstances where individualized assessment is not appropriate. That's how I would put it. Your Lordship says invidious. I would say inappropriate, and it's inappropriate in a case of this kind for reasons I've said. I regret to say many times.
It's highly appropriate in this case, isn't it? What you're saying is it's impractical, but the fact it's impractical doesn't mean that you do what's inappropriate. You then change the position. It's just unfortunate, but it's not inappropriate.
Well, we've been around this issue a number of occasions. We would say that there's a fundamental value of access to justice, and a fundamental value of providing a remedy where there's a wrong. And if what are in essence common law rules relating to damages, these are not. These are rules which the common law has devised to do justice in cases. If those rules don't work to provide access to justice and to right a wrong in practice, the law can adapt its rules accordingly to meet the justice of the case. That's how I put it. It may be too radical. It may be too unconventional. But Lords, that's how we put our case. But Lord Barrows.
Thank you. I'm just wondering if there's not a tension between your call for a conventional award and what you've previously described as the lowest common denominator. Because it would seem to me that a conventional award would be difficult to pinpoint if you are at the same time thinking about the lowest common denominator. I'm not quite sure how the two fit together. I mean, just to put figures on this, let's assume that the lowest common denominator is somebody whose loss of control is worth £5. Let's just assume. I mean, is that what you then mean by there's a conventional award of £5? I mean, what is the conventional award in comparison to the lowest common denominator?
Well, Your Lordship will have gathered, perhaps I didn't express it very clearly, but I was saying my primary submission was a matter of labelling, and the Mr. White labels the uniform sum I'm seeking a conventional award, and if so, I say so be it, and if that's the way it's analysed, then it can be analysed in that way. So yes, I would say that the two should be aligned. The way you would get to the conventional award is by looking at the value of the interference with the right. In other words, on the lowest common denominator basis. Of course, I know Your Lordship is particularly clear about this, but even if we were talking about distress, we're effectively talking about conventional sums, because we're simply we're just on a kind of sliding scale. We're just saying someone's a bit distressed, so that's £100, or they're quite a lot distressed, so that's 500, and they're very, very distressed, that's 750. But where there's not a distinction between a mathematical and exact assessment of loss on the one hand, and on the other hand, an arbitrary assessment. My lords, my lady, I before any more questions, I move on. My next heading was user damages and or negotiating damages, and that's, as I indicated at the outset, that's the alternative way in which the respondent puts his case as to how to satisfy the same interest test under CPR 19.6. The court will have seen how the Court of Appeal dealt with it. Paragraph 67, 68, electronic 225, 226. It was said, I think strictly speaking, obiter, that this was a fairly arguable point and would therefore go forward. We say that conclusion is supported by the analysis of negotiating damages by this court in the On-Step and Morris Garner case. I hope Lord Reid will forgive me for just saying a bit about it. I don't, because I'm just going to go very briefly through his judgment. That was, of course, a case concerned with breach of contract. But Lord Reid begins his analysis of first principles from paragraph 24 onwards. That's at 1245 of the bundle, with a discussion of user damages in tort, noting that substantial damages are awarded where there's an invasion of rights to tangible, movable or immovable property, but no pecuniary loss or physical damage. And then that's at paragraph 26. And then he goes on to deal with the well-known speech of Lord Shaw of Dunfermline in Watson, Laidlaw, and then his conclusion on this part of the judgment at paragraph 30, that's at electronic 1247, where an unlawful use is made of property and the right to control such use is a valuable asset, the owner suffers a loss of a different kind, which calls for a different method of assessing damages. He then goes on to conduct a comprehensive analysis of Rootham Park Estates and a subsequent, not entirely consistent case law on those damages. And I'm not going to say anything about that at all, because those in general concern the position in contract. But I do want to just draw attention to a paragraph which Lord Reid cites with apparent approval, I hope I'm not wrong about that, paragraph 59, which is at 1256 of the report, and where he quotes from a decision of the Court of Appeal in Jaggard and Sawyer, where the court itself cites a passage from the well-known case of Tito and Waddell number 2, and where Mr. Justice McGarry in that case sets out what looks like the statement of a general principle, and as I say, cited with apparent approval, which is, if the plaintiff has a right to prevent some act from being done without his consent, the defendant does the act without seeking that consent, the plaintiff has suffered a loss that the defendant has taken without paying for it, something which the plaintiff could have required payment, namely the right to do the act. The court therefore makes the defendant pay what he ought to have paid the plaintiff for what it is the plaintiff has lost. And we say that that's in summary the principle which can be applied in this case.
I referred to that yesterday as something for nothing.
Yes, and the lady is right, and in fact, those are words used by Lord Reid later in his judgment. We also note that Lord Reid uses the language of loss of control when explaining the awards of negotiating damages for breach of contract. These being explained by the claimants having lost a valuable opportunity to exercise their right to control the use of their information. That's at paragraph 84, electronic 1262. And then I won't read them out, but we rely on the way that Lord Reid summarises his conclusions from paragraph 91 onwards. At 91, he says that there are certain circumstances in which the loss, which compensation is due, is the economic value of the right which has been breached, considered as an asset. The imaginary negotiation is merely a tool for arriving at that value. The real question is as to the circumstances in which the value constitutes the measure of the claimant's loss. He goes on to say, that in the next paragraph, 92, that such circumstances can exist where the breach of contract results in the loss of a valuable asset created or protected by the right which was infringed. Where the claimant has in substance been deprived of a valuable asset, his loss can therefore be measured by determining the economic value of the asset in question. And the phrase that my Lady Arden referred to, the defendant has taken something for nothing, which the claimant is entitled to require payment. And we say that reasoning, and of course, I repeat, we of course accept that the case is concerned with contract damages. And what's said about the position in tort is obviously obiter. But we say that what that demonstrates is that it's arguable, at least, that in the present case, Google has deprived the members of the class of a valuable asset, namely the right to have their data processed in accordance with data protection. In other words, the right not to have their data used for Google's advertising purposes without, in this case, their consent. They've been deprived of the right to have their data processed lawfully. Yesterday, my Lord Reid. I'm so sorry.
Do you accept, Mr. Tomlinson, that if user damages are appropriate in this case, the starting point for the assessment would be to identify what use Google made of the data in the individual case? and then one would use that as the basis for the hypothetical negotiation.
Well,
So it requires an individualized assessment, doesn't it? You've got what is the something that's been taken for nothing. Unless you know that, you can't put a value on it.
well, my lord, can I answer this your lordship's question by making my next point, if I may, and then perhaps come back to it if I haven't dealt with it properly. Because what I was going to go on to say was that my Lord Reid yesterday, and this is the similar question to that raised by Lord Leggett today, raised the question of how user damages could be assessed on a uniform basis in a case of this kind. And that's my Lord Leggett's point as well. As I apprehend it, you've got to look at it suggested that you've got to look at the individual use that's made by Google of a particular class member's data. Well, we say that's not the right approach in this case, that one would look at the negotiation on a class-wide basis. In other words, there's a hypothetical negotiation between Google and a body representing the users of Safari who are negotiating standard terms. We put paragraph 42 of the draft particulars of claim 293. We say such a hypothetically negotiated fee should be on a uniform or per capita basis, reflecting the generalized standard terms in which Google does business. And that we say makes perfect sense in a situation of this kind, because imagine Google saying to its, or we say we would imagine Google saying to its users, look, we want to use your data. We'd like to use your data for advertising purposes. And this is a valuable thing for us. And we're prepared to pay, we're prepared to pay you to give your consent for your data to be used for those purposes. Now, we're prepared to pay each person who permits us to do this a sum of money. And the sum of money is not going to be very large, because the value of data is in mass aggregation of small pieces of data. But it's not going to be zero either, because this data is and work has been done on how people might value their data in this kind of terms. I mean, people say to consumers, well, if an internet company said to you, can I use your data for my advertising purposes and do anything I want with it? How much would you be prepared to take for that? What would they have to pay you to persuade you that that was something that you would agree to? As I say, I don't realistically say it would be it wouldn't be a large sum per consumer. On the other hand, it wouldn't be a zero sum per consumer, we would say. So we say that's realistic. It's very common. Something like Spotify, just to take a random example, Spotify offers you two ways of using its services. You can use it for free and have adverts, or you can pay and not have adverts. And there's a value that puts a value on directly on your decision whether or not to permit adverts. And Spotify either gets its money by you paying for its service, or alternatively by presenting adverts to you as its user.
Well, unfortunately, the result of the GDPR isn't that anybody pays me for using my data, but I click on I accept several times a day whenever I want to visit a website.
Well, your lordship should be clicking on I don't accept, because the website will still allow you to use its services. They've got to do that. So you have to reject all cookies. My lords, my lady, I see the time, and that may be a convenient moment.
Yes. Thank you. We'll adjourn then for 5 minutes. I think we're ready to resume. Mr. Tomlinson.
Lord, yes, Lord Burrows has a question.
Thank you. I'm just thinking about this negotiation of negotiating damages that you have in mind, just so that I'm clear what you're positing. Is it the case that you're saying this is done on a class basis? So one collects all the claimants for the period of time that we're actually talking about and imagines that they are all collected together, negotiating with, or a representative on their behalf, negotiating with Google, and one then ends up with a sum that Google would be prepared to pay in order for consent effectively to be given to the use of the data over that period. Is that what you have in mind?
Lord, yes, and I mean, and on a practical level, if one was talking about this kind of negotiations in a real world way, I mean, you'd have a consumer. There'd be negotiations between representatives of consumers and those who wanted to use consumers' data to arrive at some collective view. You wouldn't be gathering, as it were, you wouldn't have a Wembley Stadium, rather bigger than Wembley Stadium, but a gathering of iPhone users all getting together and then electing a representative who went along to Mountain View and negotiated with Google.
Yes. So in a way, it's a technique to aggregate all the breaches and losses of control. Is that right?
Well, it's a technique to put a value on giving Google permission to do what it's done without permission.
Right. How then would one divide up if one had arrived at that figure between the different claimants?
Well, it would be a standard figure per person. It's as I say, the Google operates on standard terms, and when you're looking at the model that we mentioned, it's not obviously not exact, but where internet companies offer you two services, one with adverts and one without adverts. They don't. If I go onto Spotify, they don't say, "I see you look at a lot of songs, so the value of advertising to you is greater than someone who doesn't use Spotify very much." It's done on a standard basis.
What I'm driving at is if you had, let's say, an overall figure of, let's say, £500,000, and you've got 500,000 potential claimants or claimants, they get £1 each. Is that what you're saying?
Yes. Yes.
Right. And is that consistent with the lowest common denominator approach?
No, the lowest common denominator approach is an alternative to that. This is an alternative way of looking at loss and arriving at a uniform sum.
There are other statutory mechanisms that could be invoked at this point, aren't there? I mean, for instance, you could have a scheme of arrangement with the creditors, those who have claims, those whom you know about, but you can get advertisements to find who they are, and then put the proposed sum to them and a scheme of allocation, and if they agree it, and the statutory mechanism is followed, that would be one method of allocating the aggregated damages.
My lady, yes.
And there may be other powers which the Commissioner has available as regulatory powers to achieve the same effect.
I confess I can't immediately think of them, but Mr. Jenner may be able to help.
Exactly. He may be able to give us some answers about that as to what the regulator can do if there are actions like this to help on issues of allocation of loss.
Lady, yes. Lord.
One more question, Mr. Thompson. In distributing your hypothetically negotiated award, how does the common law provide you with a principle of each person gets the same, as opposed to a principle of heavy internet users get more, for example. I mean, what common law principle are you applying there in quantifying the damages?
Well, the interesting way of putting the question, which I hadn't quite thought of, and I apologise. What we would say is that the only way that you can arrive at a collective figure is by a collective negotiation, and the collective negotiation involves standardised terms, and therefore some people would be. I apprehend this is the basis of your lordship's question. Some people will be undercompensated, and some people will be overcompensated. But I don't see that there's any common law objection to assessing damages in that way.
Well, except for the principle of the common law that damages are meant to be compensatory and not undercompensatory or overcompensatory.
well, that's the question as to the extent to which that principle applies in this kind of action is obviously central to this appeal. And your lordship's made the point on a number of occasions, and obviously I agree with you. If one follows strict compensatory principles, a representative action of this kind doesn't work. I entirely accept.
Thank you.
I'll deal briefly with Google's objections to this to this approach, which, for present purposes, I apprehend are three. The first is that user damages are not available, or negotiating damages, because data isn't property. I think lost. Sorry. No, I'm so sorry. I thought we had a technical difficulty, but not. The objection that such damages are not available because data isn't property, and my short answer to that submission is that it's clear from the cases that user damages in tort, or what you might call quasi-tort, extend beyond property rights. The obvious example being a breach of confidence, which although there's a lot of debate about it, I think it's fairly clear that confidential information is not a property right in the ordinarily understood sense. On the other hand, as Lord Sumption at paragraph 120 and Lord Carnworth at paragraph 135 in one step note that the principle has been applied in contexts where there's an analogy with the taking of property, and we submit that analogy extends to personal data. Secondly, there's the objection, which is based on Douglas and Hello, that it simply doesn't make sense to imagine someone negotiating away their data protection or privacy rights. To which our response is, in the words of Lord Reid in one step at paragraph 91, this is an imaginary negotiation, which is simply a tool for arriving at value. So we say that this tool can be applied in the present case. Thirdly, it's said that user damages are only awarded in very limited circumstances. And we say, well, that may be right, but these circumstances are although of course I accept that there is no case directly on point, these cases are analogous to the breach of confidence cases where user damages have been awarded, and the other tort cases involving property rights or rights analogous to property. The valuable data protection rights of members of the class are ex hypothesi breached by Google, and Google has exploited that data to its considerable economic advantage. We obviously don't know what value that data has to Google, but we do know that Google's business is data processing and selling advertisements as a result, and that Google is one of the most successful corporations in the world using data for those purposes. And we say that user damages is an appropriate way of assessing the damages in a case of this kind. So, my lords and my lady, that's all I was proposing to say on the first issue. The second issue is obviously the question of the meaning of the same interest requirement under CPR 19.6. Some of this material has been gone over already, but it's perhaps important to look at CPR 19.6 at the outset. It's at 8.12 of the electronic bundle. It's not of course an issue. Everybody accepts that this is the modern formulation of a principle originally applicable only in the Court of Chancery, but extended to the common law courts in 1873. And I don't think it's said that the slight difference in formulation of the words makes any difference to the over the years makes any difference to the principle. The crucial words in 19.61, where more than one person has the same interest in the claim may be begun, or the court may order the claim be continued by or against one or more of the persons who have the same interest as representatives of any other person who have and then it's perhaps important just to note the rest of the rule. The court may direct a person may not act as a representative. That's sub rule 2. Any party may apply to the court for an order under paragraph 2, and then this 4. Unless the court otherwise directs any judgment or order given in a claim in which a party is acting as a representative under this rule, A is binding on all persons represented in the claim, but B may only be enforced by or against a person who's not a party to the claim with the permission of the court. So the test, as set out in the rule, is whether there's the same interest, and that's a permissive rule that if there are persons who have the same interest, a person with that interest may sue as a representative of the class of persons with that interest. And we begin really with a simple submission that in this case, it's obvious that the members of the class have the same interest in the claim. Their interest is in establishing that Google breached their data protection rights by the operation of the Safari workaround. Lord Sales, I apologise, I didn't see.
Could I just ask you a rather technical question on 19.64? B, it says an order may only be enforced by or against the person who is not a party to the claim with the permission of the court. How does that work with a damages claim? Because Google will only have to pay damages to a claimant if they've got an order against it.
We would be seeking an order that Google pays damages to the representative on behalf of the members of the class. So if such an order were to be made, and we don't apprehend there's anything in the rule that prevents such an order from being made, then that's how it would proceed. The individual members of the class wouldn't have to bring individual enforcement claims.
No, but I was understanding one of your points on sub-rule 4 to be that if individual claimants didn't want to be bound by the judgment, they could opt out. And I'm just wondering how that works with a damages claim.
Well, the sub-rule 4A is binding on all persons represented by the claim, but may only be enforced. And the way that that's been interpreted in the cases is that someone who doesn't wish to be represented can make an application to the court, effectively either to be joined as a defendant or for an order that they be not part of the class represented. So there's, I'll refer to it briefly later, but there's the case of John and Rees, which involved a dispute between members of the constituency Labour Party, and there's all kinds of rows about who was on which side, and Mr. Justice McGarry said, really, it doesn't matter if you don't like it, you can. If you think this representative doesn't represent you, you can come to court, tell us, and we can make an order.
All right, thank you.
My lady,
Yes, may I just ask you a quick point to get it out of the way in case we don't come back to it? I mean, I fully accept the answer you've just given. But one of the points, objections to a representative action that's been made is that the damages would be paid into a trust fund, which, so far as it was not taken up with meeting claims, would have to be applied CPRE. But why is that not so? Why can't you provide that after the end of the limitation period, any balance on that fund is returned to Google?
well, Melody, that CPRE, perhaps it was a red herring. CPRE was mentioned in our evidence at the outset because that's the way that balances have been dealt with in other jurisdictions, and indeed are dealt with under the Competition Act regime. But we accept that that can't be done without legislation, and absolutely we accept that the balance would be repaid to Google if it wasn't distributed.
Question while we're on this topic, Mr. Tomlinson.
Of course.
The other part of the payment to the litigation funders. Suppose that damages are awarded on the basis that all the claimants are entitled to £500 or whatever it is. What is the legal basis that you rely on to say that the first part of that sum can be paid out to litigation funders, even though it's been awarded as damages to the claimant, without their consent to, because they've never signed up to the litigation funding?
Well, because that's the cost of obtaining the damages. It's the cost of getting in the fund.
Yeah, but it wasn't a cost they authorised. They didn't choose that the funders should get the first 40% or whatever it is.
Well, they didn't. Your lordship's right. Of course, they didn't authorise it. But the position is without the funders, there'd be no fund at all. And as I say, they have the option to come to court to say we don't want anything to do with this action, or we want to proceed on our own, or we simply we're not interested in it in any way.
I know, but I suppose they want their damages after they're being ordered. I'm not sure quite how you say that damages which have been awarded to them can be allocated without their permission to the litigation funders.
Because, well, we say that on the basis that that is a necessary cost of acquiring those damages, and without that cost being incurred, there would be no damages.
And what's the legal principle there, more precisely?
Well,
is it the court's inherent jurisdiction? Is it some restitutionary principle? That, what is it?
A trustee, and we accept that the analogy is not exact, but we've constituted in this litigation Mr. Lloyd as the various documents we've prepared, Mr. Lloyd as the trustee of the fund, so he would hold it on trust for the members of the class, and a trustee is entitled to remuneration for the costs of getting in the trust property, and it's really on that analogy we say that one of the costs of getting in the trust property is the costs of funding the litigation.
Okay, thank you.
So, my lords and my lady, the 19.6, I say, is in general terms, and the words are same interest, and we say that the Chancellor, that the reasoning of the Chancellor on this point, which is at page 228 of the electronic bundle, paragraph 75, is absolutely clear and correct. Once it's understood that the claimants that Mr. Lloyd seeks to represent would have had their BGI something of value taken without their consent in the same circumstances during the same period, and are not seeking to rely on any personal circumstances affecting any individual claimant, the matter looks more straightforward. The representative class are all victims of the same alleged wrong and have sustained the same loss. It goes on to say that reliance on individual circumstances is disavowed, but it does not mean that the representative claimants don't have the same interests in the claim. As he goes on to say, Google's not in a position to raise any defence to one claimant that didn't apply to all of them. The wrong's the same, the loss claimed is the same, and therefore they have the same interest. And we say really that's a clear and obviously correct reasoning. That's what the position is in this case. Every member of the class has an interest in demonstrating that Google has acted unlawfully, and he or she is entitled to damages. And there really is no reason to qualify the words of 19.6 by any further restrictive rules or further conditions, and that approach is entirely consistent with the historic purposes of the rule, which is, as said in many cases, and going back certainly to the 19th century, it's a rule of convenience, which should be adapted to modern circumstances to do justice in individual cases. We say that's exactly the way that the Court of Appeal interpreted it, and obviously correct. Google's response to that comes in three parts. The first is to say that the Chancellor wasn't entitled to take that course because there's a clear line of authority. The second is to say, well, Parliament or the government have been thinking about this, and they haven't actually taken any action, so the courts shouldn't actually do anything to encourage or facilitate such claims. And thirdly, that really primary legislation is needed and rigorous safeguards. My lords and my lady, we say that none of those arguments are correct. Can I begin with the the question of the case law. The Google submits, this is at paragraph 58 of its case, that every member of the class must have suffered the same damage, or their share of a readily ascertainable aggregate amount must be clear. We say that if by same damage it means they mean exactly the same damage, then that's simply not right. It's not what's said in the leading case of Duke of Bedford and Ellis, which is at 849. As the court knows, that case it's been referred to on a number of occasions already, but that was the case involving an extraordinarily wide and ill-defined class of growers who were wishing to market their produce in Covent Garden. Fluctuating class and very difficult to know precisely its limits or who was in it at a given moment. The leading speech, of course, is given by Lord Macnaghten, who expressed at 856. I mean, I'm not going to go through it in detail, but the tenor of his speech is absolutely clear. We say the tenor of his speech is the rule requires flexibility and its purpose is to do justice in individual cases, and he ultimately gets to the page 8, having electronic 856, having talked about the disapproving an earlier decision of Temperton and Russell, which confined the case to property disputes, says that the old rule halfway down was simple and perfectly well understood. It was originally a rule of convenience. For the sake of convenience, it was relaxed. And then he says, as the court knows this, given a common interest and a common grievance, a representative suit was in order if the relief sought was in its nature beneficial to all who the plaintiff proposed to represent. I mean, that's not intended, we would say, to be, as it were, a set of tests. He's just explaining in general terms how the rule works. But a common interest and a common grievance, and the relief being in its nature beneficial to all, we say are only present in this case. That they have a common interest in suing Google, common grievance against Google, and it's beneficial to all for them to recover the damages of the kind that we say under issue 1 are recoverable in a case of this sort.
You have to promise them, though, or give some assurance that the distribution will be on a fair basis. I suppose you might say, well, of course, it will be subject to the approval of the court.
Well, my lady, that's exactly what we do say, and we've made it clear throughout that we put proposals to the court, and the court may not have seen these in detail because they're not really an issue on this appeal, but we've gone to very great lengths. I mean, we've set up a consultative committee containing, among other things, a retired Lord Justice and well-known individuals. We've set out a whole series of documents and plans as to how to deal with this, and we've made it clear that what we do is subject to the direction of the court. And Mr. Lloyd, I think, as I said before, is accepted to be a highly reputable and responsible individual, and he would take no steps whatever unless those were authorised by the court conducting this litigation.
And the court could ask the regulator if it needed assistance.
The court could certainly seek the views of the regulator as to how to deal with with this, and the regulator may or may not have power to assist. I would say it's not an issue that I would care to express a view on at this point. But we say that the formulation of Lord Macnaghten, although not intended to be a statutory test, is clearly satisfied. Lord Morris and Killannon entirely concurred. Lord Shand was of the same view, and I'm so sorry, my Lord Sales.
Yes, so just to pick you up on even Lord Macnaghten's formulation, might it not be said, if where the relief is sought is damages which will be sums of money in the pocket of individual claimants, that it's difficult to say that that's relief in the nature which in its nature is beneficial to all, because it's necessarily the case that each person who's entitled to the damages has the benefit of that for themselves personally, not for everyone else.
Well, I have two responses to that. The first is that that's not how it's been interpreted in subsequent cases. The subsequent cases where damages have been awarded. But my more general point was, we would say, as a matter of ordinary language, is it beneficial to someone to have an award of damages? Yes. Is it beneficial to each member of the class for them each to have an award of damages? Yes. Is it beneficial to all of them to have an award of damages? Yes, we would say.
Right, thank you.
Lord, the court, I'm sure, has seen, but Lord Brampton and the Earl of Halsbury, the Lord Chancellor who dissented not on the basis of how the representative action rule was to be applied, but they thought that the claimants should be divided in, that the plaintiffs, as they then were, should be divided into groups, and one group who used yearly cart stands. I'm not entirely sure what a yearly cart stand is, but the operators of yearly cart stands should be in one action, and the operator of yearly pitching stands should be in a separate action. So their complaint was not that the plaintiffs couldn't represent large and fluctuating classes of people, but really they should do it in two bits. And indeed, in all the cases, and I think Mr. White made this point, and of course I accept it, that claims were made for an account of overpayments, what was said to be overpayments to the Duke, who was demanding more money than he was entitled to according to the plaintiffs, and an account, a payment of sums found due on those accounts. All the members of the court, the members of the committee, accepted that those claims were maintainable, but not as representative claims, because they had individualized assessments, but they were properly joined in. The Google places strong reliance on the decision of the Court of Appeal in Marked and Night Steamship, which is at 875 of the Electoral London. That was a case arising out of the Russo-Japanese War, where a ship had been, the Night Commander had been sunk by a Russian cruiser on the grounds that it was carrying contraband. Contraband, I think it had been just shortly after the time of the Russo-Japanese War, was agreed that contraband fell into two categories. That basically it was either war material, or it was material directed towards armies or governments. And if a ship sailing into a war zone contained contraband, then it could be properly attacked by one of the warring parties. So it was important that the Night Commander owners ensured that it didn't have any contraband on board, because otherwise Russian cruisers were lurking, as indeed happened. and one sees the way the case was put at 878, just at the top of the page. This is the argument of the plaintiffs. The Knight Commander was sunk on the ground she was carrying contraband of war. As far as all the shippers of non-contraband goods are concerned, the cause of action is it was a breach of contract on the part of the ship owners to be carrying contraband of war, which might render the non-contraband parts of the portion of the cargo liable to seizure. So their complaint was, you shouldn't have had contraband on board. That was a breach of contract. The action, I'm afraid to say, sadly familiar problem. There was a certain amount of dithering and waiting until the very last day of the limitation period, and the writ was issued in a rush, and was I think, as Lord Justice Fletcher Moulton points out at 888, it can hardly admit of doubt that these two writs as they stand are hopelessly bad. The plaintiffs have made an utter mess of it, and they hadn't actually made it clear it was a representative action in the writs at all. But the issue that was made, the point was made in correspondence, and the issue was whether a representative action in those circumstances was permissible. As the court knows, by a majority of 2 to 1, the Court of Appeal decided it wasn't permissible. Lord Justice Vaughan Williams, as part of the majority, held that they didn't have the shippers. I'm so sorry, I should have said the shippers of the plaintiffs. The shippers of the cargo on board the Knight Commander didn't have a common purpose in the litigation, and they weren't relying on a common statutory right. So he took the view that they had to have some common purpose in their, it appears, in the venture that they were engaged in. But he doesn't say anything about damages. The Lord Justice Fletcher Moulton, who was the other member of the majority, said at 894 to 5. So that page, internal 1040 to 1041. The relief sought is damages. Damages are personal only. To my mind, no representative action can lie where the sole relief sought is damages, because they have to be proved separately in the case of each plaintiff. Therefore, the possibility of representation ceases. And as pointed out in the later case, that note, a note to that effect, appeared in the White Book. I'm not sure it was the White Book at that time anyway. The annual practice for many years, and based on that dictum of Lord Justice Fletcher Moulton. But it is a dictum because it wasn't the reason given by the other member of the majority, Lord Justice Vaughan Williams. We say that insofar as that the proposition is that you can never bring a representative action damages, that isn't right, because it wrongly assumes that any claim for damages will always require separate proof for each claimant. That's not the case, where each member of the class claims the same loss. If there's no need for individual consideration, then there's no reason why representative action can't be brought. We don't, it's not a necessary part of our argument to say that court should overrule marked, but what we do submit that it's wrongly decided because the too narrow a view was taken of the same interest test. The common purpose required by Lord Justice Vaughan Williams goes far too broad, we say. The fact that there are separate contracts is, for the purpose of this action, irrelevant, because what matters is the shippers have shipped contraband goods, and it is said that they have a general obligation not to ship contraband goods, which applies to all cargo owners. And as Lord Justice Buckley, the dissentient, put it at 901, sorry, let me find the passage. Cargo owners on a general ship are not partners. They have a common interest in the ship in which their goods are carried. In respect of that interest, they're positioned to claim relief which is common to all of them. And he went on to say, and this is at the foot of the page, just under the passage I just read, to enable the representative firms to recover damages which upon the footing of the declaration may be recoverable by them, requires no doubt further steps, such are always necessary in a representative action to give the represented parties the particular relief to which each is entitled in respect of the common relief, which is for the benefit of all. Subsequent proceedings would be necessary, and in those it would be open for the defendant to contend that as regards any particular plaintiff by representation, he was for some reason personal to himself not entitled to recover. Such difficulties always occur in every representative action. The purpose of Order 16 Rule 9 was, I think, to extend to common law actions the flexibility which for many years has enjoyed actions in the Court of Chancery. And he refers to a passage from Lord Lindley in the Taff Vale case, which is cited in our case, where this passage which he quotes earlier in his judgment, page 898, where Lord Lindley says that again makes the general point about it being a practical rule of convenience which needs to be adapted to modern circumstances.
There's really a great deal of disagreement on the principles between Lord Justice Buckley and Lord Justice Fletcher Moulton. Lord Justice Fletcher Moulton is making the point you can't have representative action for damages alone because the claimant, the plaintiff as he then was, couldn't sue on behalf of the other persons who'd been wronged because his claim wasn't their claim. There were distinct claims for damages, and that's also the reason why he explains why estoppel wouldn't operate. But Lord Justice Buckley is really, I think, envisaging a two-stage procedure where you have first a representative action to get a declaration establishing the liability of the defendants in principle, and then subsequent proceedings for the recovery of the consequent damages owed to the different claimants.
Well,
I think the logic of his position is consistent with Lord Justice Fletcher Moulton, and he's suggesting a procedural way in which you can deal with the problem.
yes, and I think your lordship is right, and of course Lord Justice Fletcher Moulton, when the question of a declaratory relief is considered, says effectively, I've never heard of such a thing. This is at 896,042. No declaration of this kind has ever been made by the English courts. It may be contrary to their practice, and it may be a very narrow dispute. And Lord, insofar as Lord Justice Fletcher Moulton says you can't recover damages in a representative action if it requires individualized assessment. I think I've already made my position clear that we accept that. If it's said to be authority for some wider proposition that damages can never be recovered, or only if there's a dispute about a common fund, then we disagree. We disagree with that.
There's certainly evidence of chancery practice whereby, for instance, a right belongs to inhabitants of an area. They don't all have the same relationship with the other party on the other side of the proceedings. But there are cases where representative actions have been allowed, and then you get proceedings under the decree to work out what each individual inhabitant is entitled to.
Indeed.
That's the thing that Lord Justice Buckley had in mind, and it was well established.
Milady, indeed, and it's a point we've made in our case, and reference to the Warrender and Queen's College case, where the Chancellor in that case says there may be disputes between the members of the class that can be dealt with at a later stage. But in relation to marked, it may be that we say that Lord Justice Ford Williams is wrong about the way he construes purpose, and the insofar as it appears to be suggested that you need a common document to if there's a representative action, that's not right. It depends on the construing the rule in the generous spirit in which it's intended to achieve the result which it's intended, namely to do justice where large numbers of plaintiffs are involved. It's interesting to note the case was considered in the Irish Rowan many years later by Court of Appeal, and which is at 972. I think Mr. White referred to this case, and it may be that there's really not much dispute about this, but in that case, at 990, Lord Justice Staunton refers to Mr. Pollock, as Mr. White said, was advancing a strong argument based on Lord Justice Fletcher Moulton, and which was rejected by the Court of Appeal in this case, and in the Irish Rowan, and if the court looks at 990 letter H, that's the point I was making about the observations of Lord Justice Fletcher Moulton recorded in the annual practice, as damages cannot be awarded, and after considering the authorities, there's a well-known passage where at 992, having referred to again the passage from Taff Vale, which I mentioned before, from Lord Lindley, and then to Mr. Justice McGarry and John and Rees, and then to a case called Moon and Atherton. Lord Justice Staunton, which is an action for damages for negligence in representative action. Lord Justice Staunton quotes Lord Denning and then says, this is quite contrary to what Lord Justice Fletcher Moulton had to say and marked, thus is the law reformed. And in that case, it was accepted that a damages action could be brought in under the representative procedure. I won't say anything in detail about David Jones and Corey, because it's very difficult to, strong though the Court of Appeal was in that case, it's difficult to see quite what their reasoning was. That's at 903. It appears that the claims for damages were not permitted to go ahead as a representative action because those were individualized claims, which again is something that proposition which I accept. But none of these are authorities contrary to the approach taken by the Court of Appeal in this case. The next authority, just to draw the court's attention to, is Mr. Justice Weinlott in Prudential Assurance and Newman, which is at page 229. Is that right?
No.
I think I may have got the reference wrong. My apologies. No, I think 93. It's 936. I don't know where I got 239 from. 93. The passage. Mr. Justice Weinlott, a case which was argued over many days, and Mr. Justice Weinlott analysed all these authorities, and then concluded at 936, letter G, in these terms. This is a case which is taken as authority for the proposition you can bring representative actions in tort. And he concludes in this way: in my judgment, it's clear on authority and principle the representative action can be brought by a plaintiff suing on behalf of himself and all the members of the class, each member, which including the claimant, has a separate cause of action in tort, provided three conditions are satisfied. And then he sets those out. You can't use a representative action to confer a right of action which doesn't otherwise, you wouldn't otherwise have. Secondly, there must be an interest shared by all members of the class. And thirdly, the court must be satisfied that it's for the benefit of the class the plaintiff is permitted to sue in a representative capacity. And I should fairly draw attention to the fact that he suggests his second condition wasn't satisfied in marked. That's at 225, just above letter D. The next authority I want to draw to the court's attention is Mr. White has mentioned it in his survey of the authorities. It's important decision of the Vice Chancellor Morritt in the case of Independente and others, and Music Online Trading.
Mr. Tomlinson, I'm so sorry. Just before we leave what Mr. Justice Weinlott says, page 938 of the electronic bundle, as I understand it, what seems to be happening in some of these cases is that it's recognised that in some cases you may have disparate claimants with some common elements in the claims that they seek to bring. So, for example, in the Mark Steamship case, all the shippers, if they were to have a cause of action, would have to show that they had, as the implied term of their shipping contracts, that no contraband would be carried, and would have to show that contraband was carried in breach of those terms. Lord Justice Buckley, as I understand his judgment there, seemed to be contemplating that you might have a representative claim on an issues basis. In other words, where everyone has to prove exactly the same things as an element in their cause of action. You might be able to have a representative claim so far as that element of the cause of action is concerned. And that seems to be what Mr. Justice Weinlott is talking about, page 255 of the report in Prudential Assurance. where he talked about there must be a common ingredient in the cause of action of each member of the class. But the reason that I'm putting this to you is to suggest that your case is different, because what you're trying to do is get a common fund of damages. In other words, the final element of what is a separate cause of action for each member of the class is what you want to fill in on a representative basis, which seems to be, if this is the right way of looking at the authorities, very different from those authorities which contemplate that you can have a representative claim in relation to one element or ingredient of the cause of action.
My Lord, I accept. I certainly accept it's different from these cases, and I gratefully adopt your Lordship's analysis. I mean, that what's happened in these cases is, as your Lordship says, that, and indeed, I think as my lady pointed out, there's always been the practice of the Court of Chancery that common elements will be picked out, conveniently dealt with as representative actions, and then other parts of the claims may have to be dealt with separately on an individualized basis. But these cases are not examples of it, but we would say that if the parties have different causes of action because their actions in tort or their actions under separate contracts, and it's clear for one reason or another that no individualized assessment of damages is required, then a representative action can be used. I mean, let me give this as an example. What would be the position if someone, if a company had been requiring the payment of a standard fee from thousands of people, and it turned out that there was an argument that that requirement was unlawful for breach of the Consumer Credit Act or something, then surely there'd be no objection to all those thousands of people bringing a representative action for damages, because they'd all be claiming the same sum back, the same £100 or whatever it was that they paid as an unlawfully extracted fee. It's only if individualized assessments, I mean, if to take my example, if each of them have been charged a different fee, taking into account personal circumstances, it may then be that the representative part of the action would have to be declaratory in relation to the statute, whatever, and the damages part individualized, but it just depends on the circumstances, we would say.
But I thought that you accepted on the primary way you put your case that there will be different damages sums recoverable by individuals in principle.
My Lord, I accept, of course, that there will be different sums of damages recoverable in principle, and my short answer to that is, if those individuals want to pursue those separately from the class, they may. But the way of making this, the way of affording practical, I'm repeating myself, the way of affording practical access to justice is to limit each claim to a standard sum.
Yes, thank you.
As I just mentioned, there's quite a good illustration of how the old Chancery practice worked, given by Lord Justice Vaughan Williams on page 882, where he cites a case of Adair and the New River Company, which Lord Macnaghten had also cited.
Yes, indeed, yes.
So in that case, judgment tells us that to establish the right of suit to a mill, for instance, the court only requires parties sufficient to secure a fair contest. The right being established in that way, consequential relief may be had against the rest in another suit. So
Yes.
you have a representative action to deal with it as what Sales put it on an issue basis. Although, in fairness, Lord Justice Vaughan Williams goes on to say, well, that was the old Chancery practice, and construing the rules made under the Judiciary Act is not necessarily quite the same thing.
Yes, although that approach, of course, has been criticised in subsequent cases and by many commentators, because simply as a matter of precedent, Lord Macnaghten in Bedford and Ellis says the opposite. He says you've got to construe the modern rule in the light of the old chancery practice. So insofar as Lord Justice Vaughan Williams, who of course was the dissentient in the Court of Appeal in Bedford and Ellis, insofar as he takes a narrower view, that can't be right.
You have a number of options, don't you? Because once on this postulate you get to the stage of a declaration, then you could either say, well, we're going to limit the damages to X, or you could say you would like some orders for the revealing of information by Google as to exactly what they did do with the information, the data. And that on the basis of that information, there might be a possibility of a negotiated settlement between Mr. Lloyd and Google, which could then be put to all known claimants for their approval. And the court might make it a condition of its approval of the settlement that it is so approved, using a statutory mechanism for approval.
My lady, that would certainly be a possibility. I have to say candidly, the difficulty with declaration approaches, that as the courts have acknowledged in the competition field, this kind of litigation is not practical without litigation funding. And litigation funders require some return on their funding. And if the relief sought is declaratory, that doesn't give them any opportunity to get such a return. So in practice, the actions don't happen.
But it's not intended that you should stop at the declaration.
Milady, I quite understand that, but the difficulty is that the practicality, as we understand it, the practicality is that the litigation funders, all they see is declarations and then further assessments and further disclosure, and they don't see a way of getting their return on their funding. It's as I said in one of the Australian cases, which I hope I'll have time to refer to. The whole practice of litigation funding is in some ways distasteful to particularly to older practitioners, where this kind of thing certainly didn't happen at one time. But I think it's been acknowledged that it's a necessity in terms of providing access to justice in
well, I hear what you say, but without any evidence, I wouldn't have thought it was what you're saying hung together very well.
Milady, I can't possibly give evidence, but Milady, if the court were to, if this action were to go forward as a representative action, we've made it absolutely clear, and I repeat it again in case it's not clear, that we go to the court and say, we require directions as to how you think is the proper and appropriate way for this action to be taken forward, and obviously we would abide by those directions and conduct the litigation accordingly. So if the court took the view that suggested by your ladyship that was a proper course, then that would be a course that we would take, and one of the points I hope to make shortly is forgive me, I'm not complaining about questions from the court. One of the points I hope to make shortly is that in the absence of statutory rules, the court must take on a very active case management duty in cases of this sort.
As it did before the time when there were rules in the Court of Equity.
Indeed. Oh, I'm so sorry.
Just to be clear, though, Mr. Tomlinson, I understand that you'll take all offers gratefully, but you're not coming to the court with any form of two-stage procedure, as I understand it, put forward as an alternative, under which, if you don't get your primary position, you'd be happy with a determination of liability on a common basis, followed up by individual assessments of damages. It's all or nothing as far as you're concerned.
Well, my lord, of course, that's right. But I'm seeking permission to one sometimes forgets. I'm not trying to solve all the great issues of the English law in this case. All I'm trying to do is to obtain permission to serve out, and the court can give permission on whatever basis the court chooses to give permission. So if it will be open to the court. I'm not urging it. I'm not inviting the court to do this, but it would be open to the court to give permission on a different basis from the basis on which it's been sought.
Well, you've just been telling us, though, it's not economically viable to have a two-stage process. I thought it's not really for us to go up making alternative procedures that litigation might be ideal, you know, but the litigation funders haven't asked for.
Well, Lord, it's, if I could respectfully say so, it's for you to make the orders that you feel are appropriate. And if those orders, I'm not able to tell you how the litigation funders will react to those orders, obviously not. But if the court thought a different order was appropriate, then obviously the litigation funders would have to consider what action they would then take. But your lordship has the way I put it. I was about to go on to another.
Sorry, but can I just a bit further? I mean, it's all very well to say really it's up to us, but if you're suggesting that we might, I mean, obviously we have your claim as it presently stands. If you're suggesting that it might be possible instead for you to have a claim for example, declaratory relief, establishing liability in principle, you'll obviously the meat that you're interested in is the damages claims that would then be consequential on it, and you've still got the same problem that you have to. I think for reasons of practicality that you've explained to us, you have to be able to persuade us that those damages claims could then be processed on the basis of a representative claimant.
Well, my lord, it's not my case that I'm seeking declaratory relief, and I was simply responding to a question from the court. But your lordship will apprehend that my client, Mr. Lloyd, is a man who is interested in providing the maximum possible justice for claimants, for consumers, and if I don't have instructions on this, but I apprehend that Mr. Lloyd would prefer a situation where if the court were minded to say the action as presently constituted should not receive permission to serve out, but if it were constituted in this way, this different way, for example, for declaratory relief, I apprehend that's something that would be of value to him. But I hope I don't stray beyond my remit. But I'm simply responding to a question from the court and trying to make the position as clear as I can. I now see the time, so I no longer have any dilemma as to whether to go on to my next point.
Well, Mr. Tomlinson, you've been very patient with our questions this morning. We realise you've still got quite a way to go, and we'll try to control ourselves this afternoon and let you develop your submissions as you wish.
But I'm obliged.
So we'll adjourn now and resume at 2 o'clock.